Welcome to our second lecture covering gender discrimination. Let's review what we covered during our first lecture. We discussed the fact that gender discrimination continues. We talked about the impact gender stereotypes can have, and that even when perhaps there's a little bit of truth to the stereotypes, they still are unlawful to use when making employment decisions. We also kind of went through the various momentous event in a particular person's employment and how gender discrimination can arise in those circumstances. We discussed disparate treatment, which is when the employer is discriminating against the employee or the candidate based upon his or her gender. Obviously, that's unlawful. When we have a disparate treatment case, that's when we consider the prima facie case, and then the ability of the employer to present the business justification for the action that, of course, is independent of gender. And then finally, the right of the plaintiff to attempt to rebut to show that the defendant's offered reason is a mere pretext. And then we discussed disparate impact. The big case here is the Dothard versus Rawlinson case, where the petite female who wanted to become a guard at a prison was denied that, and the U.S. Supreme Court said disparate impact is a real theory under the law, and employers will have to show a business necessity before they're going to be able to use those statistics in that way. We discussed gender plus as well, gender plus discrimination. That's when, while the employer may not discriminate against all members of a particular gender, when that person's gender is combined with another fact, then that becomes unlawful discrimination if the combination of those two facts are what results in the discrimination. Okay, so let's advance to slide 31, which is where we were when we were last together. So we're going to discuss how gender stereotypes can impact discrimination cases. One of the very important cases in gender discrimination is the Price Waterhouse case. It is a U.S. Supreme Court case, and it held that an employee is discriminated against that when an employee is discriminated against due to his or her failure to meet sexual stereotypes, that type of discrimination is actionable. In this case, Ms. Hopkins is a woman, and she was denied, I believe it was a partnership, or perhaps she was terminated. I can't remember the specifics, but in any event, her personality was kind of brash. She was an aggressive, assertive woman, and Price Waterhouse was a partnership. Probably still is a partnership, I guess, I'm not sure. And it had many female partners, but the female partners it had tended to fit into a stereotype. They were perceived of as ladylike. They were not overly aggressive. They were more traditionally feminine in the way they present themselves. Price Waterhouse also had male partners who were brash and aggressive and maybe a little bit uncouth. But what Price Waterhouse didn't have were brash, aggressive female partners. And so what Ms. Hopkins said is, look, I get it. There are women who are partners here, but there aren't women who are partners with my personality. And yet there are plenty of males who have my personality. And so therefore, this is a case of me failing to meet a gender-specific stereotype. You might also call this case kind of like a gender plus case. You could be a female, but you couldn't be a female with a particular type of personality. The Price Waterhouse case is interesting, although I'm not sure the U.S. Supreme Court was thinking in these terms, but this is kind of the mechanism by which people who want to expand the scope of Title VII to include sexual orientation and transgender situations within the umbrella of Title VII. The idea being that for example, a gay male employee fails to meet sexual stereotypes about men, because the sexual stereotype is that a man is going to be attracted to a woman romantically, whereas a gay man is subject to attraction to men. And so therefore that gay man fails to meet the sexual stereotype in a way somewhat analogous to the way that Miss Hopkins failed to meet the sexual stereotype that Price Waterhouse imposed upon her. You can also see that argument perhaps even more strongly in the case of transgenderism. In this situation, we have someone who was identified as a particular gender at the time of birth. The birth certificate noted a particular gender, and then once this person became an adult, this person then began, or at some point began, to identify as a different gender. And so this person who the records reflect is, we'll say, I'll just pick a gender. We'll say that the birth certificate reflects that this person is a man and that this person self-identifies as a woman. Well, if this person self-identifies as a woman, very possibly this person wears clothing associated with women, styles hair in a way that is more commonly worn by women, perhaps wears makeup in a way that is more commonly done by women, perhaps has undergone surgeries or treatments that have feminized the appearance of this person. And so you could see all of these actions are removing this person who legally is a man and is identifying this and saying, well, this person, we expect a man to look in this way, and yet this person doesn't look in that way. And so in a way somewhat analogous to the Price Waterhouse case, that transgender person is not meeting sexual stereotypes. At this point, as we've noted before, the vast majority of U.S. circuits have not adopted this approach, but the U.S. Supreme Court has not opined on this, and so it'll be interesting to see how this develops. And of course, this assumes that the Congress doesn't pass a statute either broadening or narrowing the scope of the statute. The Price Waterhouse is a really important case. You need to know its name, and you need to know its significance having to do with sexual stereotypes. Go on. Let's talk about grooming standards. We've already talked about this a lot, but we'll spend a couple more minutes on this. Generally speaking, dress code and hygiene and personal grooming codes that employers have are pretty insulated from discrimination law. Employers are given a fair amount of flexibility in this area to advance its own business goals. Having said that, though, it's not that it's impossible for a dress code or a personal hygiene code that an employer might have to run afoul of Title VII. If a standard is unlawful, the employer can't successfully say, well, I mean, the employee knew when he or she applied for the job what the standard was. We made it really clear. And so it's a little too late for the employee to be complaining about it now. That's almost never going to work. You can't say, well, what we're doing is unlawful, but the person knew about it before they came on board, so therefore that excuses our illegality. As you can hear, it doesn't even sound like a good argument, and it certainly doesn't work with dress codes. So most dress codes aren't going to be unlawful, but if it is unlawful, it doesn't matter how clear it was to the applicant what the policy was. One example, though, of a dress code or personal hygiene standard that would be unlawful would be when a particular requirement is leveled at one group and not the other group. And it's not having to do with gender, cultural specific expectations. For example, yes, an employer can require that a woman wear a skirt and a female employee wear a skirt and a male employee wear pants. But the employer can't say, well, women have to be under this weight, but there's no restrictions on men. That would be an example of a prohibited type of code. Generally speaking, dress codes that recognize that there are different social expectations about appearance are okay, as long as they don't put an undue burden on one gender versus another. So let's say you had a policy that said women can wear whatever they want, but men have to wear a three-piece suit. That would put an undue burden on men compared to the burden that's placed upon women. So an example of a code that has been upheld is that supermarket clerks have a dress code that requires that supermarket clerks wear a tie, and that female employees do not wear pants has been upheld. So generally speaking, especially if the two standards are on roughly equal base levels in terms of the cultural expectations, those are going to be permitted. But if men have more freedom or women have more freedom, or if one seems to convey a different status, that's when it becomes problematic. For example, if an employer permitted men to wear normal business attire, but women had to wear a uniform, that seems to be setting up a hierarchy, and so therefore that would be unlawful. If the woman has to wear a uniform, then the man ought to have to wear a uniform. Let's consider a few scenarios. So male employees cannot successfully sue for gender discrimination based upon not being allowed to wear long hair, even if women can wear long hair. So that would be an example of a permitted gender distinction. Let's consider our second scenario. Bob owns a line of cosmetics and other grooming products called Qualiface. All of the makeup artists working for Qualiface are required to wear black at work. Male employees must wear black pants and black t-shirts, and female employees must wear black skirts and black tops. Bob believes sales will be better if female employees are dressed in a feminine way. Mary, an employee of Qualiface, is fired for wearing pants at work. Since she's a woman and the dress code is that skirts have to be worn, then Mary isn't going to be successful in this area because a policy that requires women to wear skirts and men to wear pants has been upheld many, many times. So unfortunately for Mary, that's not going to be a successful avenue for her to explore. Let's consider this scenario. The dress code for Scorpion Cosmetics requires all employees to report to work in uniforms. The policy also states that female employees are required to wear makeup. However, the only requirement for men is that they keep their hair and nails trimmed. Under Title VII, female employees at Scorpion Pride do not have a valid discrimination case because the Act does not prohibit an employer from using gender as a basis for reasonable grooming codes. Now, this would fall into that undue burden area. So let's say that Scorpion had very detailed, involved process that the woman has to follow in order to be appropriately made up. And let's say it takes her 30 minutes to apply, the foundation and the powder and the concealer and the mascara and the eyeliner and the makeup and the blush and the nail polish and all of that. And it's very, very involved and specific. It's not a 2 or 3 or 5 minute thing. And then the males have to do nothing along those lines. That's when you're getting to that undue burden area. But what the court says here is that, maybe it's going to take the woman a little bit longer to get ready for work than the man, but it's not outside of a reasonable range. Let's consider the next scenario. So Mary identifies as transgender and prefers to be called Mario. Mario would like to follow the employer's dress code for men, but the employer requires that Mario follow the female dress code. In Texas, the employer would be permitted to do that. Under federal law, the employer would likely be permitted to do that. As we talked before, the Second Circuit and the Seventh Circuit and the EOC would probably say no, but the vast majority of parts of the country are in circuits that would not require that the employer agree with Mario that Mario is in fact a man. Of course, many states and even some localities do recognize transgender protection, and therefore in those jurisdictions the employer would be required to acknowledge that Mario is identifying as a man and therefore apply the male dress code under those circumstances. Again, just because the law permits in Texas and in many parts of the country this type of decision, it doesn't mean that the employer can't permit Mario to follow the male dress code if that is what the employer wants and what Mario wants. It just gives the employer additional options in this area. Again, the exception is when the dress code is creating a perception about the employee. So, for example, if men are expected to wear business suits and women are expected to wear smocks, that's communicating a status difference, that somehow or another that the men have a higher position in the organization, even though they happen to be occupying the same position. I'm not going to focus on the Kelly case. It's not tremendously relevant. Again, if you have more information about it, we have the OIA link here that you're welcome to explore to find out more about the the U.S. Supreme Court decision in this case. But let's consider Jesperson. Now, this case didn't actually go to the U.S. Supreme Court, but I think it's a good example about the dress code differences. In this case, we have somebody who's a bartender in a casino in Reno. She's been working there for many, many years, and she's been successful, but she doesn't want to wear makeup in her position. She doesn't think it's consistent with how she wants to present herself. And that's worked at Harrah's for many, many years, but now Harrah's is requiring that beverage servers wear stockings, colored nail polish, and make up their hair, and also wear makeup. Jesperson refuses, and she's subsequently dismissed. She sues, and the court finds that even though we have this unequal burden standard, it just wasn't that much more burdensome for Jesperson. She didn't present enough evidence that it really was burdensome for her to do this, to even present a tribal issue of fact. So it never even went to the jury about whether it was that unequal. You don't need to know the name of this course, but what this course demonstrates, hopefully, is that, you know what, dress codes get a lot of leeway. They don't have to be exactly the same level of burden for men as for women, or for women as for men. Let's consider customer preferences. As you probably have heard in previous cases, guess what? Courts don't really care very much about customer preferences unless we're talking about personal modesty type of issues. So customer preference is just not a legitimate reason to prefer one gender over another, just like it wasn't a legitimate reason to prefer one race over another, or one person of a particular nationality over another. So again, unless we're talking about modesty things, just not going to fly. Let's consider the scenario. So Mary is a qualified carpenter. The business where she works is losing business because most clients don't like the idea of female construction workers. They feel like they can't trust the work of a female employee doing construction work. Because Armadillo is losing business, it fires Mary into those circumstances. I mean, after all, Armadillo is saying, look, we're not discriminating against Mary. We put her into this position, but gosh, we're losing all of our clients. We're going to go bankrupt. You can see how Armadillo is in a real pickle here, but the law is very clear. Armadillo needs to suck it up. They can't dismiss Mary because it qualifies as gender discrimination. And again, if we allowed customers to be agents of discrimination, then again, we won't be moving forward on these types of issues. That's at least the logic here. Let's consider another scenario, and we'll talk more about, we'll go through what the law requires in this area, then we'll talk about one approach to handling situations like the one that we're seeing in this situation. So we have Bob. Bob loves his shoes. Anyway, he does not want to be assisted by male store clerks. So he happens to frequent Slipper Town. That's his preferred shoe stopping place. And since he buys lots of shoes, the management there really kind of wants to cater to Bob. I mean, that's understandable. They don't want him going across the street to another shoe store. And so one of the male clerks, male clerks, Larry, he'd like a piece of Bob's business, and he works on a commission, so it's important to him, to get as much sales as possible. And so under these circumstances, does Larry have a claim about Bob? If Bob is told that he cannot, that Larry cannot serve him. Larry probably does have a claim under these circumstances because Bob has identified it as, I don't want males to assist me. That is probably a legitimate claim. Now, of course, can Slippertown say to Bob, well, Bob, we insist that Larry here meet your needs. Is Bob going to stick around? He's been very clear he doesn't want a male clerk. I mean, unless this is a town with just one shoe store, probably Bob is going to be out of here, right? So it's not as if anyone's going to be able to force Bob to have Larry sell him shoes. But still, given the way this particular fact pattern developed, I would say that the Slippertown is on thin ice, or slippery ice perhaps, with respect to Larry. So let me tell you how this works out in the real world. The approach here is to communicate to Bob that Bob can approach the sales clerk that he wants assistance from. And so instead of saying to Bob, well, Bob, we'll send the female store clerks over to see you, they should instead say to Bob, let's assume Bob says, well, I don't want help from a male clerk. He should say, okay, Bob, well, I'll tell you what we'll do. You select the clerk when you come in that you want to assist you. And now, whatever the basis for Bob's choice, it's not the store making that choice or communicating that choice. I've seen this done in the area of salons. Let's talk a little bit about salons, because I think salons is a good indicator. And there's both gender issues in play here, but probably in this case, in the salon case, probably more racial issues in play here. In a salon setting, there are oftentimes a certain degree of specialization. There are some stylists who specialize in hairs of various textures. So you might have a stylist who usually does a Caucasian hair or Asian hair, and then you might have another stylist who usually does African American hair. There are differences in styling preferences, difference in the various chemical treatments that might happen. For example, a relaxer might be a product that an African American would want on his or her hair. And there might be certain styles of hair that are more popular in a particular cultural group. And so again, a stylist can be expert in all the methods, but oftentimes he or she prefers to focus on one method or another. It's also not unusual for a customer base to kind of develop along those lines. So for a styling salon to be predominantly one race in terms of its clientele, or be predominantly another race in terms of its clientele. And so those are some distinctions. But let's imagine that you happen to have a salon that has a diverse base of stylists. And let's say, so you have some Caucasian stylists, some male stylists, some African American stylists, just a mix of differing groups. And so you have a customer come in. You notice that this customer is African American. And so the customer says, I'd like to get my hair cut. And you say, and so now it's somebody has to assign this customer to a particular stylist. And there's several ways of doing it. One way would be next stylist up, who next person's free will take this customer. Another way that sometimes is happening is to have pictures of the stylist displayed and ask the customer, which stylist would you prefer? And many times, not always certainly, but many times the African American stylist will think to himself or herself, I have more confidence in somebody who has hair texture similar to mine, because this person probably has more experience dealing with this hair. So very often that African American customer will pick an African American stylist. And so that's a way of setting up a situation that is likely to be successful, where the customer is feeling comfortable with the stylist, and the stylist, probably more likely than not, is going to have the skills that are going to allow that stylist to be successful. Now, if the stylist honestly says, listen, I'd love to get the business, but I am not as familiar with performing the service that you want, certainly that can be something that can be brought up, and assuming that that's not a way that the stylist is using to avoid serving a customer of a particular race, then that can be something that can be explored. But allowing it to be the customer's preference is a better way of handling it. But let me give you another scenario. Let's say we have the same circumstance. We have a diverse group of stylists. We have a stylist of any particular race walk in. It's not a stylist, a customer of any particular race. And that customer says, well, I only want a stylist of X race, whatever that race might be. That's when the salon can't say, oh, well, we happen to have this Caucasian stylist, or we happen to have this African American stylist. That would be unlawful. So instead, that's why you want to steer that conversation away from that kind of thing. Instead, say, here, we have these 3 stylists here. Here are their pictures. I'll be glad to tell you something about their skill set, and then allow the customer to make that choice. So that is a lawful way. You might say at the end of the day, well, you end up at the same point. Bob is always going to go approach the female clerk, but it's a way of keeping Bob as a customer but not violating the law. Let's consider another scenario. In this situation, the police chief of a small town, I said Farmersville, reassigns female patrol officers from high crime areas because people living in those areas think, female police officers not quite as tough as a male police officer. Obviously, that's not true, but that's their perception anyway. Anyway, under those circumstances, the female police officer can bring an action of gender discrimination under those circumstances because they are being denied those particular opportunities. It may even be the case that male police officers would also be able to advance a claim, because if they are assigned to the high crime areas, that means they're not being assigned to the low crime areas. So it might be a more stressful job to work in those areas. Let's consider the Hooters situation. We've all heard of the restaurant Hooters, restaurant that is famous for its wings, but perhaps it's a little bit more famous for its waiters, or more correctly, waitresses. And so here are some photos. Many of them are of very questionable taste. I apologize. But you can see here that there is a flirtatious, sexualized aspect to the Hooters business model. Part of the reason, at least, that Hooters thinks many of its customers come is not just because the wings are good, but also because their servers are very attractive and are dressed in a flirtatious, somewhat revealing way. Well, as a result of this of this business model, Hooters was not employing men as waiters. It hired men to run the locations, to cook, to bus tables. There were lots of men employed at Hooters, but they would not be waitresses. Being a waitress was a more lucrative job for the staff to have. And so some men who applied and were turned down filed charges with the EOC. The EOC investigated and found that Hooters was engaged in discrimination. The case resolved itself with Hooters apparently paying a significant fine to the EEOC, but I don't know that Hooters has ever changed its business model. Let me present to you the argument that Hooters advanced for its policy, and we'll talk about a similar argument in a few minutes. And we can see here in this picture we have somebody who's obviously a man who is attempting to sell wings, and the point is, look, nobody's going to be that excited about buying wings from this particular person because this particular person doesn't have the particular appeal that some of these other waitresses would have. And so basically the argument was that being a female was a BFOQ of being a waitress at Hooters. That a waitress at Hooters wasn't just responsible for getting the order correct, getting the food delivered promptly, being courteous, all the things that we ordinarily expect for a waiter or waitress to do, but was also required to be attractive and to be appealing to customers who wanted to see a pretty young lady in a rather revealing outfit. So that was a BFOQ, was the argument. Again, the EOC didn't buy that. Their response was, look, you don't have to be a female to be able to take an order for wings. You don't have to be a female to be able to deliver the food and to be polite and gracious. And so that's the distinction. And again, the Hooters settled with the EOC, but I don't think their business model really changed. Okay, we'll talk about the Southwestern Airlines case in a little bit. So keep that in mind as we go forward on this one. Let's talk about international issues. What is the scope of Title VII outside of the United States? Well, certainly if it is an international company that is employing employing people within the borders of the United States, those individuals are covered by Title VII. But what about the circumstance in which you have a U.S. corporation that employs U.S. citizens outside of the United States? Most of the time, for most statutes, the laws end at the borders of the country. That's not true for 100% of statutes, but that's the usual point at which the law ends. So for most statutes, when a U.S. company is doing business in France or Kenya or Japan, the U.S. business doesn't have to comply with U.S. laws in most respects. But Title VII is a little different. Title VII says when that U.S. business is in France or Kenya or Japan or wherever, if the employee at issue is also a U.S. citizen, then as a general rule, Title VII applies. Now, of course, many times U.S. companies that have branch offices in France or Kenya or Japan are going to hire French people or Kenyans or Japanese people to man their offices. And so when those French people or Kenyans or Japanese are in those offices of the U.S. corporation, but still in France or Kenya or Japan, Title VII doesn't apply to them. Now, it could well be that there are French laws that apply or Kenyan laws that apply or Japanese laws that apply, but Title VII doesn't apply. So here's the general rule. As a general rule, Title VII applies to U.S. citizens employed in U.S. corporations' international offices. Now, I said as a general rule, but there is an exception that's important, and that is sometimes when the corporation is in that foreign country, the laws of that country may conflict with Title VII. We see this most commonly in the area of gender discrimination. So there may be laws, I guess I'm thinking about Saudi Arabia, wherein women, this law has changed now, but for a long time women weren't allowed to drive. So let's imagine that a woman applied to be a truck driver for a U.S. corporation and applied for that position in Saudi Arabia. Well, the law prohibits her from having a driver's license and therefore probably from having a commercial driver's license. Under those circumstances, the U.S. corporation is permitted to discriminate against her because she is a woman, even though she's a U.S. citizen, because, again, when that law was in effect, she would have been prohibited under the law from taking that particular action. It's important to know that cultural preferences in the other country are not a lawful defense. So let's say, while, again, we'll use the example of Saudi Arabia. Let's say that, and let's assume this is the case, I'm not saying that it is, but let's imagine that even though now it's lawful for women to have driver's license, it is not at all considered appropriate within the culture for women to drive a car, on a professional basis, like a truck driver or a taxi driver. Even though it's not unlawful, it's considered very, very socially inappropriate, wrong, immoral, something along those lines. And so again, the U.S. citizen applies to be a truck driver to work for the U.S. company in Saudi Arabia. Well, in this situation, the company is going to have to comply with Title VII because we're not talking about a law anymore. We're just talking about a cultural preference. Let's consider this scenario. So Camel Computers is a U.S.-based company, so Title VII ordinarily applies to it. It has its operations in United Northlandia, a developing country. The culture of the company, focus on the word culture here. The culture of the company, well, I can't mark it here, but the culture of the company does not permit women to deal with men professionally, though there is no law limiting women to jobs that do not require much interaction with men. Mary, who's a U.S. citizen who happens to work for Camel Computers in United Northlandia, is denied a promotion because the promotion that she's seeking, she would have to interact with men a lot. And again, this would be considered violating the cultural expectations in this country. Under these circumstances, because there's no law in United Northlandia that prohibits men and women from interacting in this way, just a cultural expectation, Mary, because she's a U.S. citizen working for a U.S. corporation, would be able to successfully advance a Title VII claim. Okay, so now we're back to the buckets. We have here our blue bucket, which is the Title VII bucket, and now we're going to switch to our green bucket for a little while, which is the Equal Pay Act bucket. Don't worry, we'll be back to the blue bucket in a little bit. No worries here, but we're going to talk a little bit about the Equal Pay Act. This is the second statute, the second most important statute we have in this area. It actually became law a year before Title VII. Of course, Title VII's long name is the Civil Rights Act of 1964. Well, the Equal Pay Act is the Equal Pay Act of 1963, so just 1 year before. This was kind of the first effort that the U.S. Congress had in addressing employment discrimination based upon a protected characteristic such as gender or race or national origin. I guess because it was the first attempt, it was kind of tentative. It doesn't provide a very large area of protection, and its damages are relatively limited. But it is an important first step. You may recall at the beginning of my first lecture, I talked about the legislative history of Title VII, and I talked about how when the Southern senator had proposed that we add race to the list of protected characteristics, there was laughter. It was considered outrageous. But also keep in mind that this same Congress the year before had passed the Equal Pay Act. So it wasn't as if Congress hadn't done something with respect to gender discrimination already. So there's kind of an interesting combination of perspectives here. It's a little difficult perhaps for us in the 21st century to look back and make sense of exactly how people at that time might have put these pieces together. But let's look at what the Equal Pay Act actually provides. The Equal Pay Act requires employees who are performing the same work for the same employer receive the same pay. It prohibits wage differentials based upon gender for jobs requiring equal skill, effort, and responsibility when the jobs are performed under similar working conditions. Of course, at this time, Title VII wasn't the law, so the Equal Pay Act, instead of being a freestanding law, functions as an amendment to the already existing Fair Labor Standards Act. The Fair Labor Standards Act is a statute that mainly has two main parts. One part has to do with minimum wage, and the other part has to do with child labor. And so this is kind of a third part of that, the Equal Pay Act having to do with gender. When the Congress decided to address employment discrimination more broadly with Title VII, they decided, no, we're not going to put it into the Fair Labor Standards Act, the FLSA, we're going to put it into the Civil Rights Act of 1964. So they're found in different statutes, but you'll see there's some similarities here. Now let's kind of unpack the Equal Pay Act because some of this might be a little bit misleading. Let's imagine you had two employees. You had Mary and Susan. They both work doing exactly the same thing every day. We'll say they're both assembly line people. They both have the same productivity expectation. They both have the same education. They both have the same number of years of experience. They both have the same performance appraisal history. Really, there's not a lot of distinctions between Mary and Susan. But let's assume that we pull up Mary's hourly rate. Mary earns $12 an hour. Susan only earns $9 an hour. So does the Equal Pay Act provide Susan with any relief? I mean, she's earning a lot less money. Doesn't really seem to make a lot of sense. Well, no, because this has to do with wage differentials between men and women. Both Mary and Susan are women. I'm not defending the wage difference. It doesn't seem to make sense. It probably should be addressed, but it doesn't violate any law because, again, there has to be a difference between men and women. We'd have the same answer if instead of being Mary and Susan, it was Larry and Bob. There can be a difference between Larry and Bob because they're both men. But now let's do it with a mixed population. So now we have Mary and Bob. They were hired on the same day, had the same performance record, the same experience prior to coming on board, the same education, the same productivity requirements. Mary is earning $9 an hour, Bob is earning $12 an hour. This is when the Equal Pay Act kicks in. This is when it prohibits that wage difference. In this situation, Mary's wages would have to be brought up to Bob's. You can see an employer might want to drop Bob's down. Okay, well, Bob, you've been earning $12 an hour. Mary's been earning $9. Let's drop you down to $9. No, that's unlawful. Mary's wage has to go up to the $12 an hour. Let's switch it around. Let's say that Mary was earning the $12 an hour and Bob was earning the $9. Same result. It's still unlawful. It's unlawful to discriminate against Bob, just like it's unlawful to discriminate against Mary. Similarly, we can't drop Mary's pay from 12 to 9. We have to raise Bob's to 12. So it has to do with gender, the differences between gender. Let's imagine this. Let's say that Bob has a job requiring the same types of skills that Mary does, but Mary's job is to type in the office and Bob's is to work on the assembly line. But they require the same education, the same effort, whatever. You might say, well, that sounds like it's an Equal Pay Act issue. No. The jobs really have to be pretty close to the same job. They don't have to be identical, but pretty close to the same job. For example, a second grade teacher and a third grade teacher probably would be considered to have the same job. But a second grade teacher and a 10th grade algebra teacher would not be considered to have the same job. Even though they're both teachers, probably the certificate that they need in order to teach would be different. Their day in, day out tasks would be different. The second grade teacher is probably a generalist. He's teaching lots of different subjects. The 10th grade teacher is really just focusing on a particular math course. So there would be significant differences between the two. If there were a pay difference, that would be fine, but not between the second and the third grade, most likely. So let's go on from here. Let's look at a scenario here. So Mary works as a sales clerk at Squirrel Eyes, which is an upscale cosmetic brand. I'm sure you want Squirrel Eyes, right? I do, certainly. Bob is also a sales clerk at the same store, so they have the same position. They're both hired the same year and have similar experience and qualifications. So this is sounding like a classic Equal Pay Act case. By the way, many people call the Equal Pay Act EPA. That can be a little confusing because we also have the statute, the Environmental Protection Act. Since this is not an environmental law course, we're not going to be talking about that version of the EPA. So if I say EPA, I mean this one. It's one of those weird statutes or weird abbreviations that apply that, can be a little confusing in this area. It's a little bit like OSU is Oklahoma State or Ohio State or Oregon State. Same idea. Okay, moving right on. Okay, so Bob is actually routinely paid more than Mary, okay? If the pay difference is because Bob has a base pay that's different than Mary's, even though he's received the same performance appraisals, then that would be unlawful and Mary would have a good claim. But let's say the difference is because Bob's able to generate more income, so he earns higher commissions. He has more hustle. He persuades more people to buy more cosmetics. Under those circumstances, then the pay differential is fine. It's okay when the pay differential reflects different skill, effort, or responsibility. In this case, his effort has resulted in a higher level of income. It could also be that both of them work on an hourly basis, but Bob over the years has just generated higher sales. So because he's been more productive, he earns a higher base pay. It would still be fine. The only thing is that the employer is going to have to prove that, point to actual numbers. They can't just say, oh, well, we just think Bob generates more sales. Well, show us the numbers, show us the math. We can't have wage differentials based upon something like age or family size. Let's imagine Mary's single, Bob's married with 3 children. That's not a basis for Bob to get more money. Bob's 40, Mary's 24. That's not a basis for more money. We've talked in the past about Title VII having a 300-day statutory period in the state of Texas. The Equal Pay Act has quite a bit longer statutory period, so it's 2 years, and actually probably at least as often as not, really 3 years. So you can see the Equal Pay Act can be advantageous to a plaintiff that missed the 300-day threshold, but still would like to pursue the claim. So this, and of course, a plaintiff doesn't have to pick. Plaintiff can sue under Title VII and the Equal Pay Act. And most gender discrimination plaintiffs, especially if there's some pay issues involved in it, will choose to sue under both statutes. Let's talk about that 3-year statutory period. And this actually is tracking with the Fair Labor Standards Act because this is the statutory period for that act. We haven't talked about that one yet in the course, but just know that this schema is set up under the Fair Labor Standards Act. Anyway, so a violation is willful when everybody knew, not everybody, but people had access to this information about Mary and Bob, and somebody just should have noticed, and somebody perhaps even intentionally paid Bob more. Let's assume this is unlawful, whatever's going on here. That would be an example of a willful situation. But let's imagine different. Let's imagine that Squirrel Eyes is a huge corporation, and this particular store is huge. And we have one department over here with Mary in it, and one department way across the store with Bob in it. And the HR people who administer those two employees are different. And they just never talked about it. And so one is paying Mary, $9 an hour, one's paying Bob $12 an hour, but neither one of it are aware that the other one is paying a different wage rate to a person of a different gender. Under those situations, we still have a violation of the Equal Pay Act because Mary's still earning less, even though there's no difference in experience or qualifications. But because it's not an intentional situation, probably the statutory period of 2 years is going to be applicable, not 3. Okay, we talked earlier about the fact that gender discrimination is a continuing problem. So let's look at a couple statistics. Now, this number 77, this number, you'll see numbers similar to this from time to time, alleging that women earn 77 cents per each dollar that a man has earned. You'll see sometimes it as low as 75 or 74. I've seen it as high as 79. There's a lot of different ways of making this calculation, and there's lots of different factors that affect that calculation. It's an interesting thing. If you have an interest in this topic, read some good statistical analysis of it. It's not really fair to say that 23 cents reflect only gender discrimination. There are other reasons other than gender discrimination that play a role in that 23 cents or whatever the number is. Some of those factors can be that women many times exit the workplace for some matter of years when they are having young children. Also, another factor is that women sometimes choose to work in industries that, generally speaking, have lower pay. Having said that, those two factors and the other non-gender specific factors don't account for all of the 26 cents. Sorry, 23 cents. Clearly, some of that 23 cents is good old-fashioned gender discrimination. Where that is, how much of it is choices that the women have made that men haven't made, and how much of it is just gender discrimination. There's some debate and back and forth about that, but wanted to share with you a little bit about that. And you can see, given this differential, the Equal Pay Act continues to be an important statute, an important area that we can see some activity. So the Equal Pay Act is not focused upon job titles. Employer can't avoid liability by calling all the women, technicians, and calling all the men technical operators or something. It's really what the actual day-to-day tasks are. If they're very similar between the males and the females, even if the titles aren't the same, there's still going to be an EPA violation. Let's consider this scenario here. Bob earns $10 an hour and Mary earns $12 an hour. They are hired on the same day and have the same qualifications and are equally productive. They do the same work. Under these circumstances, the employer is in violation of the EPA with respect to Bob. So again, it applies to both men and women. There are some exceptions. Times where there doesn't have to be complete equality in the pay. For example, seniority and productivity are two areas that can be different. So if Mary has proven higher sales, or if she's been employed by the company longer, she can be paid more. Similarly, Bob, if he has higher sales, or he makes more widgets, or whatever the particular task is, he can be paid more if he has more seniority. Those are considered valid bases for having a pay differential. Let's consider a couple of scenarios here. A hospital's male orderlies and female aides perform essentially the same job, even though they have different titles. Under the EPA, they need to receive the same pay despite the differences in job titles. And again, there could also be some differences in terms of seniority or things like that. But once those are adjusted for, then you need to pay both the men and the women the same amount. Let's consider Mary's situation. Mary is what's called an image technician. Her job is reviewing photographs for placement in a stock images catalog. She's got some male colleagues who also review photos for placement in stock image catalog. But guess what? They have a different title. They are photo analysts. She's actually being paid less than her male colleagues for doing essentially the same work. Again, Mary will be successful if in fact she's earning less money, if both the image technician and photo analyst jobs require the same skill, effort, and responsibility. And again, they really do need to have very similar job responsibilities. This is another example. This one might be a little bit, well, this is a little bit like the second and third grader versus the third grader, a second grade teacher and third grade teacher scenario. So we have two coaches here, Mary and Bob. They're both coaches for Frisco High School. They both have the same educational credentials. They have a bachelor's degree in physical education. Bob coaches the boys basketball team at Frisco High. Mary coaches the girls basketball team. Both of the teams have performed very well, but Bob's pay is higher than Mary's. It is true that Bob is earning more money than Mary. The high school defends the pay differential by saying that Bob's basketball team is more popular. More fans go to see the boys' games than the girls' games, and so that ought to be the basis for Bob to earn more money. That doesn't play out. That's not a legitimate basis. So under those circumstances, Mary can prevail. But let me change up the facts a little bit. Let's assume that Bob is managing a few different basketball teams. Let's say there's a varsity, junior varsity, and sophomore team. Mary only manages the one team. Well, under those circumstances, there is a significant difference in responsibility. It's reasonable that Bob earns more. Let's assume that Bob's team has been much more successful. It's gone to state in the 2 times in the last 5 years. Mary's team has never gotten out of regionals. Well, that would be another reason why Bob might be paid more. Perhaps Bob has worked for Frisco ISD for 5 years longer than Mary. That would be another basis for Bob earning more. Let's say Bob has gone back to school and got his master's in physical education or kinesiology. Again, that would be another basis that would justify Bob earning more money. When one gender earns more money than the other gender, it is unlawful for the employer to reduce the wages of the higher earning gender. Let's consider this scenario. Mary and Bob, both recent grads, are hired to be computer analysts. Over lunch, Mary discovers that Bob is earning more money than she is. Mary contacts personnel saying, hey, I want to earn what Bob does. But instead of raising Mary's pay, they lower Bob's pay. Under this scenario, both Mary and Bob can sue. Mary can sue because, she was earning 15% less than Bob. Bob can sue because his pay was dropped in violation of the act. In this situation, Bob wouldn't even have to know anything about, he doesn't even have to engage in oppositional behavior under these circumstances. I'm not going to focus on this case. It's a rather old U.S. Supreme Court case, and I don't think that the court today would rule this same way. So I'm going to fly through it. But if you have an interest, it's interesting historical analysis, and I would be curious to hear what you think about this case. But you don't need to know the name of the case, and I'm not going to ask you to ask questions over it. Let's look at comparable worth. If you follow international employment law, and I'm sure you all do, of course, because it's fascinating stuff, what they have in the European Union is very different than our EPA. Let's first of all talk about the concept of comparable worth, because it's going to sound a little bit like what we have, but the scope of it is just way broader. So so comparable worth would be a Title VII action for pay discrimination based upon gender. You notice we're talking Title VII instead of EPA here. Okay, so note that. So a Title VII action for pay discrimination based upon gender, in which jobs held mostly by women are compared with somewhat comparable jobs, so not like second grade teacher versus third grade teacher, but more like second grade teacher and police officer, for example. Held mostly by men in regard to pay to determine if there is gender discrimination. The idea of comparable with this type of analysis actually is the law in the European Union. So if you're a kindergarten teacher, you say, well, gosh, the level of education I need, the number of hours I have to work is similar to what an accountant needs to work. In this culture, there's lots of female kindergarten teachers, and most accountants are males. I don't know if that's true or not, but let's imagine it's true. So under the European Union comparable worth standard, yes, you could make that argument and possibly recover. Under the EPA, that's a loser argument because there just aren't enough similarities between, accountant and kindergarten teacher. Kindergarten teacher and first grade teacher, sure. Accountant and mid-level bit, probably not even there. I don't even know what similar to an accountant would be, but you might have levels of accountants, maybe internal audit versus some other function, maybe accountant to Department A versus accountant to Department B, assuming the departments are about the same size. That would make up an EPA claim. But let's pause here for a second and talk about something that I haven't really brought a lot of attention to, and that is the EPA is a pretty narrow statute. As I said before at the beginning, the EPA was kind of the Congress's first attempt to address employment discrimination. So they were pretty hesitant to, kind of dipping their big toe in the water, so to speak. With Title VII, and even more so with subsequent statutes, they were more aggressive, more kind of willing to put more burdens on the employer. So you can see that Title VII is a more likely route to be able to advance a comparable worth because there are much fewer limitations on what plaintiffs can do. I'm not going to tell you, though, that a comparable worth analysis under Title VII is going to take you dramatically farther than you would have with EPA. The court case law just isn't there to support that. For the most part, you may go a little bit farther. Two jobs that aren't quite going to pass muster as being the same type of job on the EPA, you might be able to make a comparable worth claim under Title VII if they're pretty close to the line. But certainly, European Union comparable worth analysis is just not going to go anywhere in the United States, at least at this time. So now we're going to flip back to our blue bucket. So we're back to Title VII. And we're going to talk about gender or sex as a BFOQ. By the way, when we talk about gender and sex in this, of course, we mean them as synonyms. And we're generally talking about the gender or sex that a person has been legally identified as having. Okay, so we're back to our buckets. And we've talked about Equal Pay Act. I don't think we're going back to Equal Pay Act, at least not for a very long time. We're going to focus back on our Title VII bucket, because I say that Title VII is the main area we're looking at for gender discrimination protections in the workplace. Okay, so we're talking about BFOQ, and just a little reminder, BFOQ stands for Bona fide occupational qualification. That's statutory. I think I have the actual statute here. No, I don't have it. Here we have it, here. Employers may refuse to hire on the basis of gender when gender acts as a bona fide occupational qualification. But the employer bears the burden of proving it, and it's not an easy thing to prove. So, this isn't a carte blanche, employers can kind of use this, and no. The vast majority of employers aren't going to have any BFOQs. They're really usually limited to jobs that require an anatomy consistent with a particular gender, or that have some modesty aspects to it. Those are usually the areas where we see these classifications happen most with respect to gender. So, for example, if I am auditioning actors to be, Romeo in the play, I can restrict myself to males, or Juliet in the play, I can restrict myself to females. That would be an example of a BFOQ for gender. As I said before, privacy and modesty are reasonable BFOQs for gender. For example, imagine that a mammography place was interviewing to hire mammographists. I'm not sure that's how, but anyway, people who do mammographies. If in the event you haven't had a mammography, the process is that the woman, and I suppose men can also have mammographies, although I think the vast majority of people who have mammographies are going to be women. Anyway, the woman does not wear a top, and the mammographist actually handles the breast, puts it on a plate, and has to manipulate it so the skin isn't turned a certain way, and so that there's going to be an effective x-ray of this. So it's a very personal activity that's happening. And so many times I think women patients would be uncomfortable with a man mammographist engaging in that kind of personal manipulation of their breasts. And so I think a BFOQ under that situation would be reasonable. Another area that might be reasonable would be a fitting room attendance, where people of whatever gender, let's say it's a fitting room just for men or fitting room just for women, and let's say people in that fitting room, as they're trying on clothes and taking off clothes, might be undressed, then you can see why they might not maybe only want sales clerks or fitting room attendants of that particular gender in that area. Now, the EOC has probably defined BFOQs for gender even more narrowly. For example, yes, you can require that a male, to be a sperm donor, a BFOQ is to be male. To be a wet nurse, which is somebody who produces milk for a baby, a BFOQ would obviously be to be female, just because, women can't provide sperm and men can't provide breast milk. So the EOC is probably a little bit more limited. I think, though, the courts would be open to a broader definition, such as the fitting room attendant and the mammographist. Here is a scenario that actually has come up and certainly is relevant. So a local TV station has an opening for an evening sportscaster. Mary has a degree in broadcast journalism. She wants the job, but she's not hired because the usual way that sportscasters have handled this in the past is to actually interview players in the dressing room, and women are excluded from going into the dressing room. Now, actually, I think they've changed that custom, and now women can be in the dressing room. Obviously, cameras have to be careful what they're taking pictures of, but they can. But even if the sports team won't allow Mary into the dressing room, she could interview men as they came into the dressing room and as they're leaving the dressing room. And so under those circumstances, it's really probably not a legitimate bona fide occupational qualification that would require that the person be a male sportscaster. And so this is something that I saw in the textbook. So or in the material from the publisher. So I'm going to mention this, but I don't really like it. So I'm kind of mentioning it almost as a cautionary tale. The textbook author says, an employer may legitimately decide not to hire individuals of a given gender if doing so would cause a logistical hardship that involves an unreasonable financial burden to the employer. The way that I have seen this turn out is especially with bathroom facilities. Let's say a particular employer, and again, this would have to be a very small employer, a struggling employer, has only male bathroom facilities. And so in order to hire a woman, it would need to have female bathroom facilities, and that might be quite expensive and beyond the financial means of that business. And so the author was saying, well, then you don't have to hire women. I just don't think that's going to fly. So I'm saying I don't agree with the textbook writer. I think I could imagine theoretically, but just in the real world, I just don't think it would happen. For one thing, I think that the idea that you have to have two gendered bathrooms is not necessarily the case. This obviously is a small company to begin with, so why not make the bathroom unisex? And maybe have a sign out when it's occupied by, occupied or not occupied, and the person would flip it. I think this would be very, very difficult to come up with an example where it really was an unreasonable financial burden to employ people of the other gender. So I'm going to say probably not. So we're up to the Southwest Airlines. This isn't so much the perception or the image that Southwest creates today, but back in the 70s and 80s, they were kind of the Hooters of airlines. They had a campaign that was love in the air. Did United help you make a love connection? Tell us your story by this date to tell us for a chance to fly away with your sweetheart. And you can see that the flight attendants were short shorts or very short skirts. They were quite young and quite attractive in most cases. And you can see with the boots and the whole ensemble, they were designed to be fairly eye candy. Anyway, at this time, Southwest did not hire men to be flight attendants. And so Mr. Wilson sued Southwest Airlines saying, hey, I'm a man, I could be an excellent flight attendant. You don't need to be a woman to be a flight attendant, because the job of the flight attendant is to ensure the safety of the passengers and also to serve beverages and meals and things like that. So the question is female sex appeal a bona fide occupational qualification for the job of flight attendant and ticket agent with Southwest Airlines? And this is just a district court opinion here or actually not here, but in Dallas in the Northern District of Texas. The court said, no, it sure isn't. Again, this is the same logic that we see with the Hooters case. And so as a result, that was kind of one, you can see the case back here in 81. That's kind of part of when Southwest Airlines began to be transitioning away from the sexy aspect of it. The court said, female sex appeal is not a BFOQ for a flight attendant at Southwest Airlines. You don't need to know the name of this case or the particulars. It's just as an example, kind of like the Hooters case, where this isn't going to take you too far, saying you got to be of this gender or that gender, unless there is a real need for that type of gender association. Let's consider pregnancy discrimination. Originally, Title VII did not cover pregnancy discrimination. This was an amendment to Title VII that happened in the 1970s. So let's consider what the PDA or Pregnancy Discrimination Act provides. It prohibits discrimination based upon pregnancy, childbirth, and related conditions. It does not cover infertility problems, although the Americans with Disabilities Act probably would cover infertility items. But the Americans with Disabilities Act was passed quite a bit after the Pregnancy Discrimination Act. Also, pregnancy discrimination has nothing to do with childbirth, leave after childbirth, or related conditions after maybe complications with childbirth. Another thing about the Pregnancy Discrimination Act is that it's not a reasonable accommodation situation. We haven't gotten to this yet, but we will be talking in other modules about the duties that employers have to reasonably accommodate religious beliefs and customs in some cases, and also to accommodate disabilities. And you can easily see how you could imagine that pregnancy could have been treated as a short-term disability that would have required reasonable accommodation. Probably if Congress were passing the Pregnancy Discrimination Act today, they probably would have included that kind of language. But keep in mind, this is an act from the 1970s. The Americans with Disabilities Act was quite a bit later, and so it has a more robust level of protection in this area. So let's look at the limitations of the Pregnancy Discrimination Act. It requires employers to treat persons with pregnancy-related conditions, in other words, women, obviously, in the same manner as persons with other medical conditions who are similar in their ability or inability to work and to provide similar leave. So let's imagine you're an employer. And again, this is before the Americans with Disabilities Act, so really people who were sick or injured, assuming it wasn't a work-related injury, had no protections at work. That didn't mean that they were fired. Most employers wanted to accommodate people, but there was no legal requirement that they accommodate people who need to be off work due to illness. So let's imagine that your employer, or the employer at issue, had Bob, and Bob had a heart attack. And as a result of the heart attack, he needed to be off work for 2 months. The employer said, hey, Bob, stay home, take care of yourself, do what you need to, come back when the doctor releases you. Bob comes back to work when he's released, continues with his career. Then Mary, she's pregnant, she gives birth, she takes off 2 months to recover from childbirth and those issues. Actually, no, not childbirth. She has complications during her pregnancy. Let me put it this way. She has complications during her pregnancy. So she needs to be on bed rest during the last 2 months of her pregnancy. Her employer says, no, Mary, we're not going to give you 2 months off because your doctor says that. Well, Mary can say, but you gave Bob 2 months off when he had his heart attack, and that was a similar period of time that he needed work off. And so therefore, if you gave it to Bob, you have to give it to me. And Mary would be right under those circumstances. But let's imagine another scenario. This time, Bob has that same heart attack. His doctor says he needs 2 months off to recover. The employer says, Bob, too bad, so sad. We're firing you. Again, this is the pre-Americans with Disabilities Act, so probably it's perfectly legal, even if the employer is being a big jerk. Now Mary, who's pregnant, learns that she needs to be on bed rest for 2 months. The employer says, Mary, we're firing you. We don't need you, given the fact you're going to be off for 2 months. Mary says, but you can't fire me. And the employer says, well, yeah, we can, because we don't have to, we have to treat you as well as we treat others, but we don't have to treat you better than we treat others. We fired Bob, we're firing you. Under those circumstances, the Pregnancy Discrimination Act isn't going to give Mary any relief. Let's imagine a different scenario. Mary's doctor has given Mary restriction. Ordinarily in Mary's job, she has to lift things up to 70 pounds on a regular basis. Her doctor says that Mary should only lift things 20 pounds or lighter while she's pregnant. Christopher hurt his back playing football 6 months ago, and so his doctor restricted him from lifting anything over 20 pounds for 3 weeks. The employer was willing to accommodate Christopher's restriction, therefore the employer has to accommodate Mary's restriction. If it didn't accommodate Christopher's, it doesn't have to accommodate Mary's. So the issue is that the employer can't treat pregnancy-related conditions worse than non-pregnancy related symptoms. Now, of course, we have the Family Medical Leave Act, which takes a fair amount of the thunder out of the Pregnancy Discrimination Act away. But there are times where the Pregnancy Discrimination Act applies that the Family Medical Leave Act doesn't apply. And so we really do need to look to both of these for the maximum coverage for the employees. And if you're an HR professional, you'll have to consider both when you're making sure that your business is complying with the requirements for pregnant employees. This is, by the way, an area that the OC is seeing more activity in. There apparently are more violations of pregnancy discrimination, or at least more claims about violations of pregnancy discrimination in the last few years than the EOC has seen previously. Now, that could be due to more information about the fact this is a covered condition, so it doesn't necessarily mean that there's more violations. Let's consider a couple of scenarios. So Mary is an employee of Grizzly Holidays. She informs her manager that she's pregnant, and a few days later, she's dismissed. If the reason for her dismissal was her pregnancy, then absolutely she has a claim under the Pregnancy Discrimination Amendment to Title VII. On the other hand, if she was dismissed because, she stole, then she wouldn't have a claim. So we have to know a little bit more about why she was dismissed. Let's consider the next scenario. So Mary is an employee at Chimp Tool Company. She informs her supervisor that she's pregnant. The supervisor feels the need that it has to lighten Mary's workload, even though she hasn't requested it. She's given simple tasks. She's excluded from office meetings and other activities. She's not provided an opportunity to effectively compete with her coworkers that financial year. Under these circumstances, because the employer has treated her differently, even though she hasn't requested it, Mary can say that she has an adverse action against her due to her pregnancy. Now, you could also call this kind of a gender plus type action, because obviously only a woman can become pregnant. And let's talk about fetal protection policies. Now, this is an interesting area of the law that we've seen developments on probably a little bit later than some of these other areas. So what are fetal protection policies? These are policies an employer has that are designed to protect the unborn child that a employee might be carrying or might in the future father or conceive. Obviously, when you're dealing with hazardous chemicals, they can impact the fertility and the possibility of birth defects in future children. And so you can see how an employer might be concerned about that, both because the employer wants to be a good member of the community and responsible with respect to its employees, but there could also be concerns about liability, because these unborn children, if they are born, can perhaps sue the employer for injuries that they might have experienced before they were born, when their mother was carrying them in the workplace. So there's kind of two motivations, the good one and the not so good one, for why the employer might be concerned about this area. Fetal protection policies probably generally are lawful, but many times the way they play out are not lawful because sometimes they are written so that only women are protected. And I'm using the word protection in quotes because they're the ones prohibited from engaging in certain actions. So they are limited from career opportunities and advancement or things like that. So when the policy is just for women and not for men, those are probably going to be violations of Title VII. Now you might say, well, it's kind of silly to restrict men from exposure to that chemical if there's no indication that that's going to negatively affect the unborn child. Obviously, the woman is the one who is carrying the unborn child. So there's certainly some science here that needs to be explored, exactly how to proceed. I guess the best answer is hopefully there's strategies to reduce the risks for anyone, male, female, fertile, infertile, employees as they interact with these chemicals, because I'm guessing if it's not that safe for the unborn child, it's probably not that safe for the employees as well. But in any event, do not have a policy that only applies to women in this area. So we have covered all of our topics that we started with. Let's discuss this case. This is not a big case, so you're not going to need to know the name of this case, but I think this is an interesting one and one that many folks are kind of surprised by when they hear this case. But when you kind of dive into the case law, you'll be less surprised by this than maybe the first thought process might be. So let's consider the issue and then we'll look at the facts. In order to sue successfully for sex discrimination, must a plaintiff show evidence of discrimination beyond the fact that someone of the opposite sex was awarded the position that the plaintiff wanted to retain? I don't really like the way this issue is described, so I wrote it, so I shouldn't complain about it. But let's go through the facts, and you'll see how it looks like a little bit of sexual harassment in a way, but the way the courts have resolved it is pretty much the way that we see these cases develop. So in this case, our plaintiff is a gentleman by the name of Jay Preston. He's a dentist. He works for this larger organization, and he says, I was discriminated against because of my gender. His particular clinic had not been making money, and so the CEO fires him. Okay, generally speaking, that seems perfectly lawful. He's replaced, Preston, after he's fired, he's replaced by Hamilton. She's a dentist with much less experience, much less impressive credentials. And there's this rumor out there that Hamilton and the guy who fired Preston were having an affair. Maybe it's true, maybe it's not. The court ultimately held that the replacement of a male employee by a female employee because of romantic motivations was favoritism, not sex discrimination. Now, we don't know for sure that Hamilton and Trojak had a romantic relationship, but the court assumed for the sake of argument that there was. And so while it would be sexual harassment to say to a woman, date me, or say to a man, date me so you can get this job, if in fact there is a consensual relationship, it is lawful for the business to prefer that person in the consensual relationship, even if it causes other individuals to be at a disadvantage. So in this case, Preston wasn't in a position to have a romantic relationship with Trojak because presumably Trojak didn't want to have a relationship with Mr. Preston. And so Mr. Preston wasn't able to be in that kind of situation, and he lost his job in favor of the person who was able to have that kind of relationship. So in that situation, you can't really claim sexual harassment when you were passed over for the person willing to have that relationship. Anyway, kind of an interesting twist that might be a little bit surprising. Again, you don't need to know the name of this case. It's not an especially important case, but it's just pointing out that, at-will employment's a real thing, and employers are entitled to make stupid, unfair, pig-headed decisions sometimes, and the courts aren't going to swoop down and fix things and tell the employer what it can and cannot do unless there's actually a violation of the law. So let's close here with just some tips. You obviously want to have a culture in your organization that says gender bias isn't okay here. You need to enforce that policy. Make sure that people know about the policy, know that it's going to be enforced. Take employee complaints here seriously, investigate promptly and thoroughly, and have consequences that are reasonable. You don't have to fire everybody every time they tell a sexist joke or make a blonde joke or something like that, but you do need to have a culture that says, no, this isn't okay, and you need to respond to things promptly and appropriately under those circumstances. Need to make sure that the pay is always appropriate. That requires audits. It has to be a continuous policy to see if there are outliers in the pay, that those are addressed promptly and appropriately. Sometimes people think that when you're addressing these issues, especially if there's a sexual harassment component, I know that's not what we talked about in this lecture, but when there's a sexual harassment component, that somehow it means we all have to act like, we're Miss Manners and we're very proper and very formal. That doesn't have to be the case at all. And so don't interpret this lecture to mean that's the outcome. Well, it's been my pleasure making this presentation today. I hope that it's been helpful for you. As always, if you have questions about the material, please don't hesitate reaching out to me at my email, cgroover@collin.edu, or even better, come by my office hours so we can talk in more at greater depth. Thanks so much for your attention today, and I hope you have a wonderful day. Take care.